Before we talk about the actual criminal homicide offenses found in the Texas Penal Code, we need to first make some clarifications. The first and most important clarification involves the definition of criminal homicide. The Penal Code defines criminal homicide as intentionally, knowingly, recklessly, or with criminal negligence causing the death of an individual. This definition includes the four offenses of capital murder, murder, manslaughter, and criminally negligent homicide. Once again, criminal homicide is a definition, not an offense. You can't be charged with the offense of criminal homicide. This is a little tricky because it sounds like an offense and includes all four culpable mental states: intentionally, knowingly, recklessly, and negligently. That's a helpful distinction because few other criminal offenses in the Penal Code include all four culpable mental states. Criminal homicide is basically an umbrella term for the four criminal homicide offenses, which again are murder, capital murder, manslaughter, and criminally negligent homicide. Speaking of the offenses, let's clarify some terms that are not used in Texas, but you may be familiar with. Terms not used in Texas include murder in the first degree, murder in the second degree, premeditated murder, voluntary manslaughter, and involuntary manslaughter. These are all terms that are used on television and in the movies, which are made in places like New York and California, generally not Texas. Texas law is very different, so you'll need to forget everything you know about murder that you learned from television and the movies if you plan on practicing or working with criminal law in Texas. In fact, a major difference between Texas and television and movie law is the concept of premeditation. In layman's terms, the act of planning out and committing a crime as opposed to committing it on a spur of the moment. How long you thought about killing someone isn't central to criminal homicide offenses in Texas. What's more important is the outcome of the conduct and the culpable mental state. For instance, whether you planned for weeks to murder another person or whether or not you did it after you got into an unexpected argument with them and did it on spur of the moment, you will likely still be charged with the same offense in Texas. In other states, the charges might be different based on your premeditation. The first criminal homicide offense we'll discuss is murder. Note, it's not the most serious criminal homicide charge, but it's listed first in the Texas Penal Code. Murder is defined in the Penal Code as intentionally or knowingly causing the death of another, or it can be intending to cause serious bodily injury and committing an act clearly dangerous to human life causing the death of another. Finally, murder can be committing or attempting to commit a felony other than manslaughter, and in the course of the act or attempt or in flight afterwards, committing or attempting to commit an act clearly dangerous to life causing the death of another. This is sometimes referred to as the felony murder rule. For example, refusing to stop when a police officer tries to pull you over likely constitutes the felony offense of evading. If in the course of the police pursuit of your car, you commit an act clearly dangerous to life causing the death of another, say, for instance, you drive on the sidewalk and run over a pedestrian, the next offense included under criminal homicide in the Texas Penal Code is manslaughter. Manslaughter is tied to the culpable mental state of recklessly. A person commits manslaughter if they recklessly cause the death of an individual. So your intent or mens rea in manslaughter is not that you intentionally or knowingly intended to cause another person's death, but that you did something that you knew could have reasonably caused another person's death, and that act constituted a gross deviation from what a normal, reasonable person would have done. For instance, a person gets a new car and takes it out on a public roadway to break it in. They go 120 miles per hour down the road, and they end up crashing and killing their passenger. Did the driver mean to cause the death of their passenger? Certainly not. But a reasonable person, even one who has never driven or even ridden in a car before, would know that that speed is very dangerous. Far more dangerous than exceeding the speed limit by 5, 10, or maybe even 15 miles an hour. A reasonable person would also know an accident at that speed is likely to cause death or serious bodily injury. So more than likely, the act of going 120 miles per hour constitutes a gross deviation from what a normal person would do. In this case, the driver could be charged with manslaughter. A final note, forget what you've seen on television or the movies. Texas doesn't have voluntary or involuntary manslaughter. There is no distinction, and there's only one offense in Texas known as manslaughter. It's a felony of the second degree. Criminally negligent homicide is the final Texas Penal Code offense included under the umbrella definition of criminal homicide, and it's a little bit tricky. You are probably familiar with the concept of negligence. We almost always see it in civil law as part of a tort lawsuit or a lawsuit alleging some party didn't do something they should have, but the act itself didn't qualify as criminal. For instance, a grocery store employee mops a floor and doesn't put out a warning sign, and someone slips, falls, and then sues the store. Not putting out the warning sign isn't criminal, but it could be considered negligent. In the case of criminally negligent homicide, we take the concept of negligence to a criminal level because it involves the death of another human being. In the case of criminally negligent homicide, a person acted negligently in a way that they did something they should have known was a gross deviation from what a reasonable person would have done, and it caused the death of an individual. A real-world example is the case of a man who repeatedly was caught operating a dump truck without the required commercial driver's license, or CDL. In fact, he had done it so often he had already received 2 traffic tickets for driving without a CDL, but he continued to drive his dump truck. One day, again driving his dump truck and speeding, he rounded a curve, crossed the center line, and hit an oncoming car, killing the car's driver and passenger. The difference in this case between a manslaughter charge, which would be tied to the culpable mental state of recklessly, and criminally negligent homicide can probably best be explained through the act. Driving a dump truck once without the proper CDL is not an act that would probably be considered a gross deviation from what a reasonable person would do, though most would probably agree it's not a good idea and certainly is negligent to some degree. In fact, ask any police officer who works traffic enforcement and they will tell you many people operate cars without a driver's license every day in this country. So if this was the first time the dump truck driver had operated his truck without a CDL and the crash occurred, then it might have only resulted in a traffic ticket, and the families of the deceased would have the option of filing a tort lawsuit to seek damages in civil court for the negligent act. What brings this negligence to a criminal level is the fact that the dump truck driver had 2 prior tickets for the offense and more than likely had driven his truck hundreds or thousands of times without getting caught and continued to repeat the behavior and was speeding. His actions were not just negligent, they were criminally negligent because they were so unreasonable and a gross deviation from what an ordinary person would do. A person who causes the death of an individual by criminal negligence has committed a state jail felony under the Texas Penal Code. We need to make a few final notes before concluding our discussion on criminal homicide offenses in the Texas Penal Code. First, it's important to understand not all acts of causing the death of an individual that are in the Penal Code are considered criminal homicide. Intoxication manslaughter is found later in the Penal Code and not included in the definition of criminal homicide. The Penal Code goes on to clarify that the criminal homicide chapter applies to the death of an unborn child unless the mother has an abortion performed by a doctor or the child is aborted by use of drugs in accordance with law. Finally, the Penal Code clarifies what's known as lesser included offenses for criminal homicide. Lesser included offenses are found throughout the Penal Code, and it is basically referring to what a defendant can be charged with versus what the jury or judge can find them guilty of at trial. In the case of criminal homicide, a prosecutor can only charge a defendant with one offense for every set of elements of the offense completed. So if you cause the death of one person in the course of committing a felony, you can only be charged with one count of murder. However, at your trial, if permitted by the judge, the jury, upon hearing the evidence, may decide to convict you of either murder or a lesser included offense. They may decide the evidence only proves manslaughter beyond a reasonable doubt, or even criminally negligent homicide. Lesser included offenses apply to offenses below the one you're charged with. In this case, you can't be found guilty of capital murder by the jury. They can't go up the ladder, only down.